The Court of Appeals, First Appellate District of Ohio, with the Honorable Candace Kraus presiding, is now in session.
Good morning.
Morning, Your Honor.
Good morning, Your Honor.
So we have one case set for argument today via Zoom, and it's Harcourt v. Strassel Construction, C250145. And we have Dennis Baker for Mr. Harcourt. Good morning, Mr. Becker, excuse me.
Good morning, Your Honor.
We have Jessica Radke for the Ohio Bureau of Workers' Compensation. Good morning.
Good morning, Your Honor.
Mr. Becker, I'll be keeping your time. It's a little bit more difficult because you don't have the podium lights here. I will let you know when you have a minute left of your initial time. I assume you want to reserve some time for rebuttal.
On behalf of Mr. Harcourt, we would request to reserve 4 minutes for rebuttal.
4 minutes. Okay, so I will keep your time and let you know when you have about a minute left of that initial 11 minutes.
Thank you.
Whenever you're ready.
Please, the court, counsel. On behalf of Mr. Harcourt, we're here to review the decision made by Judge Dinkelhocker, which basically denied his right to participate for an additional condition in the workers' comp case, in his workers' comp claim. Mr. Hark was initially injured in November of 2007. He had fallen from a roof. His claim was initially allowed for a wedge compression fracture of the first lumbar vertebrae. For that condition, he proceeded to a surgical procedure in early January of 2008. His claim was then subsequently amended in June of 2009 to include a herniated disc at L4-5, as well as substantial aggravation of pre-existing lumbar spinal stenosis at L4-5. As a consequence, then his claim was then amended further in 2010 in February to include 3 additional conditions: substantial aggravation of pre-existing degenerative disc disease at L3-4, L4-5, and L5-S1, as well as lumbar facet arthropathy, but no specific level was assigned for the facet arthropathy and thus covers the entire lumbar spine. That led to a second surgical procedure done in September of 2010 with Dr. Schwetzenau, which fused the L3-4 and L4-5 levels. As a consequence of those 2 surgical procedures, Mr. Harcourt was then fused from T12 through L2 and L3 through L5, leaving one segment open, and as described by Dr. Newman, is being subject to a double lever procedure because of the fusion both above and below. It was Dr. Newman's opinion that he developed what is known as adjacent segment syndrome for the condition at L2-3, requiring a 3rd surgical procedure, which is the condition that's brought us here for you today. This matter was tried to the bench before Judge Dinkelhocker. He denied the condition. Judge Dinkelhocker observed on page 6 of his decision, the court can certainly see the positive aspects to the presentations and opinions expressed by both experts. Though each is steadfast in their reasoning and opinion as to the plaintiff's current claim, the court cannot be so sure. Reluctantly, the court cannot give more weight or importance to the findings or opinions of Dr. Newman versus Dr. Vogelstein. That brings us to the basic principle found in court law that when there's multiple factors that cause a condition to develop or an injury, that each is considered a proximate cause. In this case, we have—
Mr. Becker, can I ask you a question before you proceed? Just so that I'm understanding, you've raised 2 assignments of error with the court, and I believe that the appellee kind of read them together as both assignments challenging the court's improper, I guess, legal standard of not applying dual causation. And I read the second assignment of error to argue that. The first assignment of error, I'm a little bit confused on what you're arguing. So could you explain if there is a difference between the 2?
I will look at the wording for both just to verify.
So what I'm trying to understand is the second argument sounds like a legal standard argument, and I'm questioning if the first assignment of error is challenging the manifest weight or if it's making the same argument.
I think essentially they kind of are. We assigned as a first assignment of error, the trial court committed reversible error when it failed to correctly apply causation as a flow-through condition. I think the court, in its opening paragraph in its decision, made the observation that paragraph on the first page of its 6-page decision, it says, by law, plaintiff must prove by a preponderance of evidence that the requested condition of adjacent segment syndrome at L2-3 level exists and was causally related to the plaintiff's roof fall in 2008. It's not directly related to the fall. The condition that developed is related to the allowed conditions for which he had surgery, causing the two fusions, the fusion to P12 to L2 and L3 through L5. It's a flow-through condition that developed because of conditions that were caused by the fall. So as a flow-through condition, it's not directly related to the fall, it's directly related to the consequences of that fall and the treatment provided for the allowed conditions. Does that answer your question?
Okay, so just tell me again, are you arguing improper legal standard in assignment of error 1?
Yes.
Okay. So there's no manifest weight argument that you're mounting here.
No, we're not arguing that if we were arguing a manifest weight of the evidence, we basically have to argue abuse of discretion. I think the trial court's decision was clear in that the judge could not make a decision as to which of the two theories of causation caused the need for the additional surgery. And under the dual causation principles and following the principles from tort law, workers' comp accepts those principles. So when multiple factors cause a condition to develop, each is considered approximate cost. And
Now,
that's
I have a question on the experts though, because it sounds like your expert testified that this was a flow through, and then the defense expert testified that he didn't have this condition at all. I mean, not that it was caused by something else.
The defense expert wants to say he did not have the condition at all, or doesn't have adjacent segment syndrome. The defense expert basically argues he does have degenerative changes. So what is the cause of the degenerative changes? The degenerative change was the product of the two surgeries. That's what made the flow-through condition. That's what caused the spinal stenosis at L2-3.
Mr. Becker, did the defense experts ever say that? Or did the defense experts say it was age-related degeneration that happens to everybody?
That's what he wants to argue, that it's age-related degeneration. I asked him a question at page 46 of his deposition testimony. And the question was, if I'm to accept your opinion on causality, I have to believe that he would have developed whatever pathology he has at L2-3, irrespective of any injury, and without the fact that he had the surgeries both above and below that injury. Dr. Vogelstein answered correct. He wanted to argue that the degenerative changes at L2-3 were natural age-related findings.
Well, Mr. Becker, if that's what his opinion was, and that was contrary to the opinion of the plaintiff's expert, then isn't it really just kind of a credibility contest between two dueling experts with two different opinions?
You have to look at the experience and expertise of the two physicians. Dr. Newman testified basically he had never seen the degenerative changes at L2-3 that Mr. Harcourt exhibited in the course of his neurosurgical practicing career. That L2-3 is not a level where you would typically anticipate those findings. Where you do anticipate degenerative changes, and we all have them, but degenerative changes in and of themselves may or may not cause symptomatology. Here you have a fusion from T12 to L1, L1 to L2, covering two levels of the upper spine, which has some degree of motion. Then you have a fusion from L3-4 and L4-5, and L4-5 is the level of most motion. What is significant is when you look at the diagnostic studies, you will see that spinal stenosis developed in Mr. Harcourt's back at two levels, L2-3 and L5-S1. What is significant about that is that those are the only two levels that are not fused. So the degenerative changes that are occurring are in disproportion to what you would normally expect, but are directly related to the fact that he had surgery. And when you have surgery, fusion-specific levels of the lumbar spine, you transfer the stress that those levels normally would experience as levels of mobility or motion in the spine to the levels above and below, because those levels are now fused and there is no motion.
Okay,
Mr.
I want to clarify your argument. It seems like the two experts disagreed, correct? The two experts disagreed as to whether the condition existed, and also disagreed. The defense expert didn't believe that the surgeries caused the current condition, correct?
Correct.
Okay, so does this come down to a battle of the experts at this point?
Mr.
Yes
Becker,
and
you
no.
have about 1 more minute of your initial time, just to let you know.
Thank you, Your Honor. Yes and no. You have to look at what was done and what the testimony is. Dr. Vogelstein acknowledges that having the fusions would have an effect upon subsequent development, and you have to look at what the allowed conditions are. The claim is presently allowed for lumbar facet arthropathy, so it's already allowed for degenerative changes in the lumbar spine. And then the question gets to be, what was the cause of the surgery at L2-3? Dr. Vogelstein acknowledges that all the medical treatment Mr. Harcourt received was necessary and appropriate. He just disagrees as to what the cause was for the L2-3 fusion procedure. Thank you.
Thank you.
Mr. Becker, are you going to reserve the rest of your time?
Yes, ma'am.
Okay. You'll have a little over 4 minutes. Ms. Rodkey?
Thank you. May it please the court. My name is Jessica Rodkey, and I represent the administrator for the Ohio Bureau of Workers' Compensation. We believe that this is a rather straightforward case. Claimant did work at Strassel Construction as a construction worker. He slipped and fell off a metal roof back in 2007 and injured his back. Numerous conditions have been allowed in this case over time due to injuries, and he has had multiple surgeries, as Mr. Becker referenced. This case stems for a request for an additional condition for adjacent segment syndrome. And here the claimant has to prove both that he has the condition and that it's caused through the work incident through some theory of causation, which could be direct, substantial aggravation, or a flow through.
Ms. Rodkey, do you believe
Yes.
that the condition, do you believe that that they prove the objective existence of the condition?
I believe that Judge Dinklager found they did not,
Okay, go ahead.
because the counsel's expert, Mr. Becker's expert, believed that he did have the condition, and our expert, Dr. Vogelstein, believed that he did not have the condition. Judge was not able to find a preponderance. He did not believe one expert over another, so he did not prove that he had the condition.
And you're reading the assignments of error as arguing basically the same thing?
That's what we believed, yes.
Okay. And after hearing argument today, are you still reading them to argue the same thing?
Well, it sounds like Mr. Becker wants to say that Mr. Becker seems to want to substitute or have this court substitute its judgment for the judgment of the trial court. Seems like he's requesting a different reading of the expert's testimony. But the bottom line is one expert says he has the condition and one says he does not. Mr. Becker's client bears the burden of proving that he has it. The argument about—
Ms. Rodkey, I asked the question because my understanding and reviewing the record is there was some dispute about whether or not there was objective evidence, that is some sort of radiological proof that the condition actually existed. Do you think that there was radiological proof that the condition actually existed?
Our expert said that he did not believe there was proof. In fact, that he, excuse me for looking at my notes, but he says There are no significant changes or progression, which would be consistent with adjacent segment syndrome. And it's objectively documented that there are no changes in his back from 2016 to 2020. He also says that there's only limited pathology at all at the L2-3 level, which is the level we're talking about, other than a grade 1 stenosis, which wouldn't cause any symptoms. So no, I do not believe there's objective proof.
Thank you.
So contrary to the argument put forth by claimant, we would reiterate that if an injury is not proven by a preponderance of the evidence, there's not a need to discuss causation. Judge Dinkelhocker reviewed the depositions of the esteemed experts, as well as several hundred pages of medical documents brought forth regarding Mr. Harcourt. Dr. Newman, who's the claimant's expert, opines that he does have the condition, adjacent segment syndrome at L2-3. As I just noted at Your Honor's question, our expert, Dr. Vogelstein, testified that he does not have adjacent segment syndrome at L2-3, but rather that his pain is coming from the L4-5 vertebra in his back. And he highlights that he reviewed the MRI, the CT scan, and all the records and found no significant changes or progression consistent with adjacent segment syndrome. The trial court gave a comprehensive decision that went through the pertinent facts from each expert, and he determined that he couldn't give more weight or importance to the findings of either doctor. As the court noted, he himself referred to it as a classic battle of the experts. Because the trial court was not swayed by either expert, we don't need to get to an analysis of causation. The judge was not convinced by the greater weight of the evidence that the claimant even had the condition. The trial court here was the trier of fact and in the best position to assess the credibility of the witnesses, review the records, and make the best decision. He did so, and just because that was adverse to Mr. Becker's client does not mean that it is wrong. He alone bears the burden of showing he has the condition before the court gets to why. His expert must be more persuasive for him to carry that burden. Here, the trial court was not persuaded by the appellant's expert. As such, the verdict for the defendant was the correct one. Thank you.
All right, thank you. Mr. Becker, you have about 4 minutes in rebuttal.
Thank you. First, when we're looking at adjacent segment syndrome, it's a condition that's caused because of a prior surgical procedure. The evidence is unrefuted that he had a multi-level fusion to 2 different areas of his low back, which causes, Dr. Newman describes, a dual or 2 lever action, creating stress from both anteriorly and superiorly, both above and below the area in question, L2-3 being the only level not fused. We acknowledge that everybody has degenerative changes, but you have to look at the diagnostics in this case. And Dr. Vogelstein wanted to hang so much of his opinion on the fact that a CT scan in 2020 did not reflect considerable changes since a CT scan in 2016. That CT scan from 2016 was not included in anything that Dr. Vogelstein reviewed. He was looking at—
It sounds like you're asking us to basically reweigh the evidence here.
No, I think Dr. Vogelstein's opinion is faulty in that he's relying upon something, 1, that's not in the record, 2, that he had never seen, and it's a passing reference in a subsequent proceeding or diagnostic study when it's compared to an earlier one. In fact—
But Mr. Becker, but you didn't assign as error that the expert relied on inappropriate material when coming to their opinion.
But we argued it in the body as to what he was looking at. We believe all along that the trial court could not make a determination whether this is natural degeneration or adjacent segment disease. If it's one or the other or a combination of both, dual causation is the legal standard, and that was not applied by the trial court.
Well, I mean,
that is our argument.
Mr. Becker, you just said that the trial court couldn't determine if it was caused by the surgeries or caused by something else. Couldn't that also be looked at as that your client failed to prove anything by the preponderance of the evidence?
If the judge had said that, I think what the judge said is you've got two theories and he couldn't decide one versus the other. To me, that is clear dual causation and the fact that multiple issues can produce a similar result. In this case, it is clear that a result occurred. And the question is, are there multifactorial issues that produce that? Does degeneration play a role? Possibly. Did the fact that he had two previous surgical procedures creating additional stress on that level and creating what is called adjacent segment disease? Possibly. What we believe is it's the theory of the two fusions creating the additional stress that advanced the degeneration that resulted in the need for the surgery at L2-3. Prior to 2020, when Mr. Harcourt presented to Dr. Newman, the history was, and Mr. Harcourt in fact testified, his condition was getting progressively worse. What we also know is after the procedure was done, his condition was significantly better, and he did not have to go through the epidurals and other treatment that he had for a couple of years thereafter before Dr. Canaris reinstituted those procedures in 2022. So you have, I can't argue that degeneration doesn't play a role, but we believe the evidence clearly showed that it's degeneration in combination with the two surgical procedures. Doesn't matter how you wish to label that as adjacent segment syndrome or advancement of substantial aggravation of pre-existing degenerative disc disease, it brings about the same result. It brought about the result for the necessity of the third surgical procedure, which now results in a fusion from T12 through L5.
Great, and you are a little beyond your time.
Thank you, Your Honor.
Thank you. Thank you both for your arguments this morning. The case is now submitted and we will issue a timely decision.
Thank you, Your Honor.
Have a good rest of your day, and that concludes court for today. Thank you.
Thank you. And as a curiosity, it looks like each of you are sitting in a courtroom, but I don't recall the court having three identical courtrooms.
That is our wallpaper.
That's your wallpaper. Thank you.
Okay.